Nervous actus interveniens means a new intervening act, and it is another legal maxim determining liability and injury on a tortious act under law tort. As a general rule, it is to be the remoteness where it is caused by human volition of a third party, or when the injury to the plaintiff might have been occasioned by the intervening act of volition on the part of the plaintiff. The question whether a person who has been initially negligent would be liable for all the consequences, expected or unexpected, probable or improbable, depends for its answer upon the application of a further test which has recently came into the prominence, the test of isolation. According to this test, where the wrongful act is isolated from the consequences by an intervening act of human volition, the chance of causation between the wrongful act and the consequences is deemed to have been snapped. Even the defendant ceases to be liable for such consequences as have arisen after the intervention of that act of human volition. The prior act having exhausted itself, chance of causation has, in contemplation of law, been broken, and wrongdoer can no longer be held responsible for further consequences. This is called as nervous actus interveniens, which, having certain exceptions, such as number 1, if the intervening act has been procured intentionally by the defendant, and secondly, if the intervening actor is not fully responsible, and thirdly, if the intervening act is such as could be reasonably anticipated, and fourthly, if the intervening act is more reflex or involuntarily done or involuntary action, it would be intervening act as in pursuance of the duty. And fifthly, the doctrine of alternative damage or choice of sum. And the very important leading cases relating to this legal maxim are Sharp versus Powell of 1872, decided by the Queen's Bench, also S.W. versus L.S.W. Company 1867, decided by the Queen's Bench, also Banwari the Municipal Board Lucknow of 1941 decided by the Privy Council. So the very exact meaning and application of this maxim is that where the intervenance or intervening act as it is done to be too remote, where it is caused by human volition of a third party. So, when the injury to the plaintiff might have been occasioned by the intervening act of volition on that of the plaintiff. So, the question is whether a person who has been initially negligent would be liable for all the consequences or all the unexpected or improbable acts or the results caused due to that action. So the very maxim decides liability as per novus actus interveniens, that is regarding how a new intervening act or a new intervening act of remote cause, how it would be liable and under what circumstances it would not be liable, as the very maxim was decided by the Queen's Bench in its first judgment regarding the maxim in I.Sharp versus Powell in 1872 and of I.Glover versus S.W.Railway Company in 1867, and that was also decided by the Queen's Bench, so also by the Privy Council in Banwari Law versus the Municipal Board Lucknow in 1941.